Hi my friends, alright, I am back and now I am going to read you the defendant's skeleton argument. Again, I will just read pieces here and there and I will this time make the actual document a little larger for you, so hopefully that will help. Alright, it starts, introduction and overview of the defendant's position. 1. By her amended application notice dated 30 November 2020, the claimant, in brackets C, seeks summary judgment on the copyright claim and either summary judgment or striking out of the defense on the misuse of private information (MPI) claim. She makes no application in relation to her claim for breach of statutory duty pursuant to the GDPR/Data Protection Act 2018. The case is wholly unsuitable for summary judgment. There is uncertainty as to a number of significant factual matters which can and should be investigated at trial, when the court will have the full picture in terms of disclosure and evidence, both from C and from others involved. This is particularly so when C's case in respect of certain important factual issues has shifted inter alia in relation to the circumstances in which the letter was written and the extent to which she had disclosed the information about the letter with a view to publication. There are now on record a number of inconsistent statements made by her that she will need to explain. 3. Specifically in relation to the MPI claim, questions as to the existence of a reasonable expectation of privacy, the weight of any such privacy right, and the relative weight of countervailing rights are all fact-sensitive. Were the court to conduct an assessment of these matters now, upon the facts stated in the amended defense, I think that is rather funny, the RRAD, it would be likely to come to the conclusion that C has not shown a reasonable expectation of privacy in the contents of the letter, that, on the contrary, she expected or intended its contents to enter the public domain, but that, even if she had a privacy right in the letter, it is slight and outweighed by the freedom of expression rights of D and others. The copyright claim is also wholly unsuitable for summary judgment. As in the privacy claim, D's defense, based on the freedom of expression of D and Thomas Markle, both as a freestanding Article 10 defense and also as part of the fair dealing defense, not only has a real prospect of success, but it is a strong case and not suitable for summary determination given the nature of the balancing exercise to be carried out. That would be so even if there were no issues as to the nature and scope of the protection of any copyright owned by C, in brackets if any, and or the extent of any infringement of that right. Number 5, but importantly, there is uncertainty as to the content or extent of the protection of the copyright, if any, that C has. That requires investigation at trial with disclosure and evidence from C and others involved, such as Jason Nov. Copyright, just as privacy protection, is a highly fact-sensitive matter. One knows nothing about the scope of protection of rights simply by looking at words on a page. Instead, one needs to assess the process by which the form of the work was created to identify whether one or more copyrights may arise, and where they do, what the protectable subject matter of each is. An important facet of the uncertainty as to the nature and scope of any copyright owned by C relates to the dispute over the contribution of others, including Mr. Nov, to the creation of the electronic draft, ED, and letter. As we understand her case, C suggests that the court should include there is but a single author herself, a single creative endeavor, a single resulting copyright, and that it is a literary intellectual creation that is all hers. Such a case cannot be made without detailed evidence and disclosure, as explained in Coppinger, 18th edition, 4-17. Where there is more than one person involved, care is required because small differences of fact give rise to very different legal results. And then they actually quote from this Coppinger, 18th edition, clauses 4-17. I'm not going to read that right now. You can, for you guys, you can actually see on the screen. You can just stop the video and read that for yourselves if you wish to. Then 6. The dispute about the nature, extent, and of basis for the contribution by Mr. Nov and others will be one relevant factor in C's attempts to establish at trial that she has a reasonable expectation of privacy in the letter. In the copyright context, it has an added significance because he and others in the Kensington Palace Communications team, the KPC team, who are alleged to have contributed to the letter, were acting in the course of their duties as servants of the Crown, and copyright that may exist by virtue of their contribution will be Crown copyright, a separate and different kind of copyright with different rules of subsistence and duration existing under Section 163 of the 1988 Act. Any protection attributable to these other contributions cannot be part of the protection of any right of C, even if otherwise the facts, when eventually investigated in detail, might have given rise to a conclusion of a work of joint authorship. And I actually discussed this on Instagram. If Mr. Nov and others had assisted Meghan as part of their duties as servants of the Crown, it may be true that they have no copyright, but that the Crown will have a certain amount of copyright. And that will be the same and will apply to a secretary typing a letter for her boss. She will have no copyright, but her bosses or the firm she works for will have copyright. Okay, number 7. The lack of clarity as to any copyright also means it is impossible to decide at this stage whether a substantial part of any right has been taken at all, makes it impossible to know what right is being balanced against freedom of expression in the balancing exercise, and impacts on the issues of the practicalities of and whether to grant injunctive or other relief. 8. In respect of the relationship between the two elements of the application, as appears from C's letter of claim, her claim is essentially a privacy claim to stop D publishing anything about the contents of the letter. The copyright claim is merely an adjunct to that. There are significant areas of overlap in respect of the argument and evidence relevant to each cause of action. As such, if the application for summary judgment fails in respect of one of the causes of action, the application in respect of the other cause of action has to be viewed against the background of a pending trial in respect of all the facts and matters of relevance to the former. Given the overlap with a full trial pending, it is difficult to see how it would be appropriate in principle or as a matter of case management to strike out or give summary judgment on one of the causes of action. To do so could risk tying the hands of the trial judge or give rise to the risk of judgments that are not easily reconcilable. The basis of C's application. The basis of C's application is not wholly clear from the application notice or the evidence in support. In the order for directions, dated 4th of January 2020, the court notes in paragraph 4 of its reasons that the application is made on the basis that D's case could not realistically succeed even if D proved all the facts it has alleged. This is consistent with the statements of M.S. Afia, 4th W.S. at, and then it's taken out, 14 and 17, that in respect of both MPI and copyright, there is no factual dispute that needs to be resolved. And I think this refers to the fact, or to the fact that Meghan now seeks summary judgment, and it doesn't speak to anything else. It basically speaks to the fact that she's seeking summary judgment because she and her lawyers feel that there's realistically nothing else that the Mail on Sunday can prove contrary to their claims. In any event, 10. If C does proceed on the basis that the facts alleged by D are true, that means, for the purposes of this application, accepting D's case on the following and other important factual issues: the circumstances in which the letter was drafted, who contributed to the contents of the ED, electronic communication, and that the process involved the Kensington Palace team, the extent to which C, which is the claimant, which is Meghan Markle, was willing to disclose and release into the public domain her personal information generally, and specifically information about the letter and its contents via People magazine and the book Finding Freedom, which will be referred to as the book. The extent to which the People interview was false or misleading, including in a way that was damaging to Mr. Markle, and the circumstances in which the articles containing the extracts from the letter came to be written and published by D, which is the Mail on Sunday. If D's case on those matters is accepted, C's application in respect of both courses of action must fail. There are signs, however, that C intends at the hearing to attack D's factual case, despite the lack of proper evidential basis to do so. C's pleaded case relies on two WS's, Mr. Scobie's WS and Ms. Afia's second WS, which was served on her behalf in opposition to D's successful application to re-amend its defense. These challenge some parts of D's amended case on the facts, and C is presumably intending to rerun that factual challenge, even though they were considered by the master when granting permission to amend. So that is now referring to when they included the book and they were given permission to include the book. Further, the grounds for the application B/1/2 indicate that C puts her case also on the basis that D cannot succeed in establishing its factual case. And here again, remember, they are now just talking about the application for summary judgment. They're not arguing the case. They are arguing whether it's going to go to summary judgment or to a trial. So 12.1 in paragraph 3 in relation to MPI relies on the assertion that neither the letter nor any part of its contents had been brought into the public domain, whether by C or at all, at the date of these acts of publication. It is clear from this assertion that C appreciates the importance to her case on MPI of establishing that information about the letter was not public at the time of the publication of the article. Paragraph 3 is, however, not correct. Even on C's case, the existence of the letter and a description of its contents were in the public domain before the articles were published as a result of the people interviews. The assertion in paragraph 3 that C herself had not brought these matters into the public domain is also a matter as to which there is a very stark factual dispute. And here I'm actually clapping because that is very true and something the judge needs to take into consideration, because by now we do know that Meghan Markle herself has agreed that she did allow for information to leak for the book, and now it's just a matter of determining when she allowed for this to be done. 12.2 in relation to copyright in paragraph 1a of the grounds, C states that D will be unable to establish that the letter and the ED recite pre-existing facts. In paragraph 1b, C states that D will be unable to establish that third parties created the wording of the letter and ED. These are disputed factual issues, and I agree. 13. To the extent that C is seeking at this hearing to attack D's factual case, it is submitted that there is simply no evidential basis for C's attack. Her approach to the evidence generally is addressed in more detail below. C has not established her entitlement to summary judgment. The procedural, chronology, and the shifting nature of C's case. A 5-page letter of claim was sent to D by C's former solicitors, Harbottle and Lewis LLP, on 14 February 2019. 2 short paragraphs of this letter were devoted to the complaint of infringement of copyright, which appears to have been added as an afterthought. In the response to the letter of claim, D explicitly alleged that C had authorized or in the disclosure of the fact and nature of the letter to People magazine. In response, on 27th of March 2019, C did not deny that she had authorized the People interviews. In fact, before service of the reply on 17 April 2020, C never denied that she had authorized or in the People disclosures. When the claim was issued, the POC did not specify what information in the letter was said to be private or what words were said to convey that allegedly private information. They made allegations of falsity in the articles without specifying the allegedly false allegations. In respect of the copyright claim, C pleaded that she was the author of the letter, but did not explain anything about the circumstances in which it was drafted. No reference was made to the ED. Some of these deficiencies were later remedied by service of a response to D's first RF1, so that was their first reply. Other unsupported allegations in the POC and also in the reply were struck out by order of the court, dated 1st of May 2020. Remember when parts of her complaint was thrown out? I think we all reported on it at the time. In C's reply, that's now paragraph 16, amplified by response to D's third RFI on the 30th of June 2020, she denied that she had had any involvement in information being given to People magazine or that she had given any information about the letter to anyone for the purposes of publication. Okay, so this is where I call perjury. Because once you've made an affidavit and once you've made a statement and once you have made an allegation against another party and that allegation is contained in a legal document, then that is called an affidavit. And as Meghan had now turned around on this whole scenario and actually admitted to allowing for certain information to be shared with, for instance, Omid Scobie and Carolyn Durand, that means that she had actually committed perjury. The only way she can get out of that is possibly because at that time, on the 30th of June, that particular affidavit may not have been submitted to court. Had it been submitted to court, she would be guilty of perjury. Following the publication, paragraph 17, following the publication of the book in early August 2020, D sought to amend its case to rely on C's involvement with the book. Namely, that C and her husband cooperated with the authors to put out their version of events by means of the book. This assertion further supports the case made in the original defense that C herself put information of a personal nature, including information about the existence and content of the letter, into the public domain. C opposed the application for permission to amend on the basis that the amendments were completely false, and in their words, utterly fantastical, and that utterly fantastical is going to come bite them in the was one phrase used by C's counsel and bound to fail, and I agree. She relied on Mr. Scobie's WS, which did not deal with a key issue as to what information he had been given about the letter, when and by whom, but chose not to serve any evidence herself. 18. On 30 October 2020, more than a year after the original POC had been served, C served a amended particulars of claim. And this is where I want you guys to just stop for a minute. A year after the original POC. People, that does not look good. If you had made a mistake in your statement or affidavit, you have to amend or change it very, very quickly. And these things happen. You may have somebody else typing your statement for you while you're dictating and they make a mistake. And when rereading it before signing it, you may miss that mistake. However, when you get home and you read it, you take your time reading it and you find that mistake, you better rush right over the following day to fix that mistake. For me, her taking a year to amend her particulars of claim means that she amended it to suit her lies. Anyway, carrying on, which sought to rely on an additional document, the ED, in the pleading as an original literary work which was copied by D. See attached images of one version of the ED, that's the letter, to the RAPOC. D responded to this amendment in the RRAD. Remember, that is the amended document, in which it asserted, having received information to this effect, that the KPC, Kensington Palace team, including Mr. Knopf, had been involved in writing the ED/letter. At about this time, C made this application and applications to adjourn the trial and stay the whole claim, both relying on the summary judgment application. Those were heard on the 29th of October 2020. The application to adjourn was unopposed and was granted. The applications for a stay and for permission to appeal were dismissed, and C was ordered to serve her amended reply. By now, 5 weeks out of time. Remember, those were the WhatsApps and texts that she was ordered to supply, and which she never did. And now, apparently, they were deleted. 20. On the 15th of November 2020, C served her RAR, responding to the amendments in the RRAD. I love that RRAD. This document contained 2 major changes in C's case. 20.1. The circumstances in which the ED, that's the electronic communication or electronic document, and the letter were written or created. I'm not going to read that whole paragraph. I'm already running out of breath. The most significant thing is that there's indication that C's decision to write the letter was taken in accordance with the advice that she had received from 2 members of the royal family. Okay, I'm not going to read the whole thing. And then 20.2, C's disclosure of information about the letter for publication. At the time, she had pleaded a response to D's 3rd RFI. Remember, RF are replies. Admitted in response 4, and then in italics, having discussed with friend A that she was writing a letter to her father at the time of penning it, and having discussed the existence of the letter but not the contents in September and December. Okay? Later in the same document, she contradicted this by saying of the letter that she discussed some of its contents by friend A, or with friend A. I just want to stop here. Remember, in September and October, end of September, beginning of October, they were in South Africa. Okay? I just want to mention that because that is rather significant. And that later, still, that she discussed the contents of the letter with her husband, her mother, friend A, and friend C, the Kensington Palace communications team, and her solicitor. That, my friends, is very significant. Because first she said that she discussed the existence of the letter but not the contents. Then she changed it to some of the contents, and then she changed it to discussing the contents of the letter with her husband, her mother, and friends A and C, Kensington Palace communications team, and her solicitor. So there is no way she can win the privacy part of this case, in my opinion. In response to Dee's request 7, as to whether she knew that any of her friends or associates were giving or would or might give an interview or information in any other form about the letter to any media outlet or to any person or persons for the purpose of publication, C had pleaded in her response number 7 that she did not know that the contents of the letter would or might be revealed or referred to by any media outlet or to any person for the purposes of publication in any medium. C would not have consented to this. Similarly, in response to D's request 16, as to whether or not C had disclosed the existence and or the contents of the letter in response to anyone for the purposes of such information to be published, or knowing that such information would be published, C answered, no, C did not. 20.4. By the time of service of the RAR, C superficially persisted in this position. See, for example, 5.5, which avers that she did not provide a copy of the letter or its contents or a description of its contents to the authors, whether directly or indirectly, and whether for publication or otherwise, nor did she cause or permit the letter or its contents or a description of its contents to be disclosed to the authors for publication. Emphasis added. However, at the same time, she pleaded an apparently contradictory case in relation to a disclosure of information about the letter and her communications with her father to the authors at RAR 8B.5. I'm not going to read the piece in italics. I'm going to move on to 20.5. This important admission by C is then repeatedly downplayed at RAR 12.7b and 14, which characterize C's admission at 9b.5 that she did cause or permit information about the letter to enter the public domain as extremely limited and legally irrelevant. So what she amended it to was that the information she allowed to be used was limited and irrelevant. C at RAR 9b.3 continues to deny D's case at 13.88.3 of the RRAD, once again re-amended document, that she decided to use her friends as her de facto media relations agents or conduits to pass information to the media and to the authors herself, as alleged in that paragraph. This denial, however, would again appear to be contradicted by 9b.5. 21. C pleaded case in the RAR is the subject of an unanswered fourth request for further information by D, dated 14th of December 2020. This makes 19 requests for information in relation to 9b.5 and a number of other requests relating to the RAR. By letter dated 15 December 2020, C refused to answer all but 4 of D's requests. And I'll leave that with you to think about. The shifts in C's pleaded case, detailed above, are far from being an exhaustive account of all the inconsistencies it now contains. The confusing and torturous account of the genesis of the letter and her subsequent communications about its existence and contents cannot serve as the evidential basis for summary determination of any part of the claim. Moreover, much of the confusion which bedevils C's case appears to have come about as a result of C being compelled to respond either to the facts put forward by D or to developments external to the litigation, such as the publication of the book. The most benevolent interpretation of this reactive approach is that C is not at all clear in relation to the letter of what took place, when, or why. Even this indicates that C's claims cannot properly be determined without disclosure and full investigation on the basis of oral evidence at trial. Moreover, were the court to find that she had made untruthful or misleading statements in the course of these proceedings, the matter is relevant to the question of liability and particularly the balancing of rights that the court must conduct. So there you have it, my friends. I'm not going to read the rest of the document. The rest of the document is lengthy and gives more specific details of each interaction between the lawyers and parties with lots of dates and comments, etc. But otherwise it is basically just a repeat of what I have already read. Those of you who wish to read and study the entire document for yourselves can send me an email with MOS doc in the heading, and I shall email it to you. You can email me at bookwormonthecase@gmail.com. I know this may have been very boring, as said by one of our other favorite YouTubers, but I'm not just here for the fun of it. I'm here to fight for fairness and transparency. So hopefully, for those of you who did find this boring, I shall be back with some more interesting gossip later in the week. I apologize for the background sounds. I have a sick dog lying at my feet and I'm waiting for the vet. So there's nothing I can do about him breathing loudly in the background right now. So until next week, for now, it is just bye.